Okay, everybody, it's about 12 o'clock, and so we are going to go ahead and get started. If everyone could let me know if they're having any audio problems, you can just type it in the chat box. I will try to address those. Sometimes audio problems can be solved by calling in. So if you can't hear me, go ahead and try to call in, and that might help. If everyone could mute their speakers, that would also help just to prevent any feedback. Go ahead and type in the chat box as we go. I will try to answer any questions that I can. If it's a complex question, I may ask that we address it at the end, or that you can get in touch with me after today's webinar so I can provide you some more detailed information. My contact information will be at the end of the webinar. All right, so today what we're talking about is the produce safety rule, and specifically folks that are qualified exempt from the produce safety rule. A lot of folks fall into that category, so we thought it was worthwhile to dive into this topic a bit more and talk about what specifically folks who are qualified exempt need to do pursuant to FSMA's produce safety rule. I work for the Agriculture Law Education Initiative. We're a partnership of the University of Maryland's Francis King Carey School of Law, the University of Maryland at College Park, and the School of Agricultural and Natural Sciences at the University of Maryland's Eastern Shore. We have a variety of different agricultural legal education resources beyond food safety, so if you've never checked out our resources, I encourage you to do so, and you can find those on our website, which is umaglaw.org. Okay, so I am a lawyer, but I'm not here providing legal advice today. This information is just for educational purposes. There's a lot of different scenarios involved with the application of this law. So for advice about how these issues might apply to your individual situation, please consult your attorney. Okay, so a bit of background before we get into the specifics. The Food Safety Modernization Act, we refer to it as FSMA, passed by Congress back in 2010, it really sort of changed the landscape in terms of food safety. It's a comprehensive prevention-based controls methodology across the entire food supply. Prior to FSMA, FDA was in the stance of investigating foodborne illness outbreaks, so a very reactive approach. And FSMA has turned that on its head, and it's now taken a preventative approach. So in that regard, there's a lot of different rules within FSMA. Today, we're just going to be talking about the produce safety rule. The produce safety rule is the rule that affects farmers most prevalently, and the produce safety rule is, again, takes that preventative approach, so puts a lot of legal obligations and responsibilities on produce growers to prevent foodborne illness outbreaks. Okay. The produce safety rule, like I said, it establishes science-based standards for the safe growing, harvesting, packing, and holding of fruits and vegetables for human consumption. So quite a broad agenda. Getting down to the nitty-gritty of probably why you tuned into this webinar today, who does this apply to and what does that all mean? Well, in the context of the produce safety rule, if you are a farm that has less than $25,000 in annual produce sales, you are not covered by the produce safety rule. And that is a rolling average for the previous 3 years. And it's also an average since we said this law was passed by Congress at the end of 2010, signed into law in 2011. These numbers have been adjusted for inflation, so I gave you some of the updated inflation information there. So it's actually $26,999 if you're using the previous 3 years of 2015, 16, and 17. So if you're a small operation, or if you're a farm that's starting out, that there's a possibility that the produce safety rule is not going to apply at all to you. On the other end of the spectrum, if you're a farm that grows, harvests, or packs produce intended to be eaten raw, and you've had more than $500,000 in annual produce sales in the last 3 years, the law definitely applies to you. And by that I mean all of the provisions of the produce safety rule are going to apply to you. And I guess you should take a step back. I really didn't get too much in depth into this in this specific presentation, but it is important to realize that this doesn't apply to all growers of fruits and vegetables. It does apply to what the law refers to as covered produce, and that is fruits and vegetables that are intended to be eaten raw. I will give you a link here to our website in a few slides, and so if you have more questions about that, there's more information on the ALEI Food Safety webpage about what specific vegetables fall within and outside of that category. But to get back to our who's covered question, so if you make less than almost $27,000 in the last 3 years, it doesn't apply. If you make more than $500,000 in the last 3 years, it does apply. But for everybody in the middle, you may be eligible to be qualified exempt from this law. And that's what the topic of today's presentation really is all about. So let's get into that in a little bit more detail, because it's unfortunately not as simple as you would hope it to be. So who is eligible for that qualified exemption? And then we'll move on after this to what does that mean. So to be eligible for that qualified exemption, as I said, you have to fit that monetary value. And for this calculation, I've highlighted, or I've bolded rather, and underlined the word food. And I'll talk about that in a second. But the average annual monetary value of all food the farm sold during the 3-year period preceding the applicable calendar year was less than $500,000. And again, that number is adjusted for inflation, and I've given you that there. I've bolded and underlined food because we're not just talking about produce for this definition. We're talking about all the food the farm sold. So that includes grain, it can be animal food, it includes dairy, it can include livestock, poultry, whatever you've got going on your farm, all of those sales. So keep that in mind, and that's an important distinction. And the average annual monetary value of all the food sold directly to qualified end users during the previous 3-year period exceeded the average annual value of the food sold to all other buyers during that period. Now, if your eyes just glazed over, I understand. That's a difficult section of the law to kind of parse out and understand, but I think we can get through it. I wanted to give you the exact language. I'm a lawyer. I like exact legal language. I think language is important. However, I do think this is worded in a slightly confusing way, and there's sort of an easier way to think about it. So in other words, more than 50.1% of the average annual monetary value of the food, which, like I said, includes everything, produce, grain, dairy, the farm sold in the previous 3-year period was sold directly to qualified end users. So this requires the farmer to do a couple different comparisons. So you need to look at, first of all, you need to look at, in the last 3 years, how much did you sell altogether? What was the total value of the food sold, to make sure that you're under that $500,000 threshold. And then you need to figure out, who did I sell that food to? How much of that food was sold to qualified end users? And I'll get into that in a second, what a qualified end user is and what type of a buyer qualifies as a qualified end user. But so how much of the food was sold to qualified end users and how much of it wasn't, and then do a comparison and make sure that you meet that more than half, meet that 50.1% average was sold to qualified end users. So let's talk about who is a qualified end user, what is a qualified end user. It's a couple different things. It can either be the consumer of the food, so an individual or a business, an individual versus a business rather, not a business. So the consumer is the individual rather than a business. So if you're selling it directly to the consumer, if you're selling it at a roadside stand, if you're selling it at a farmer's market, if you have folks come out to your operation and you're selling it directly, that is a consumer. Or if you're selling it to a restaurant or a retail establishment that's located in the same state or reservation as the farm that produced the food and not more than 275 miles from the farm. So to be a qualified end user, you either have to be a consumer, which is an individual, not a business, an individual, or it can be a business if the business is a restaurant or retail food establishment that's located within your same state or within 275 miles from the farm. So that's what a qualified end user is. We get a lot of questions about qualified end users because there's a lot of different scenarios where this can be a little bit confusing. One of them is, what about if you're selling produce to a food hub? Does that qualify as a qualified end user? FDA has given us a bit of direction on this, and so basically food hubs with a farm-to-business model are unlikely to meet the definition of a qualified end user. If the food hub is a farm-to-consumer business model, it may meet the definition. And so I know that probably doesn't clear it up for everyone, but that's the guidance we have thus far on food hubs. So don't take it for granted that if you're selling the majority of your food through a food hub, that's the end of the analysis. It's really not. It's going to depend on what the food hub is then doing with that food. So is the food hub acting like a wholesaler? If they're acting like a wholesaler and they're then giving that food to other businesses, then they may not qualify. If rather the food hub is acting like a retail store, like a grocery store, where you're selling it to, you're giving it to the food hub and the food hub's giving it directly to the consumer, that food hub may very well meet the definition of a qualified end user. What about a produce auction? Similar type analysis. So as long as the farmer is selling the food through the auction instead of to the auction, it may qualify. And a restaurant or retail food establishment buying that food at the auction may be a qualified end user if they fit those geographical restrictions. So if they're within the same state or within 275 miles from the farm, or if the food is sold to a consumer through a produce auction, then it doesn't matter where the location of the consumer is. So I got that question recently at a workshop that I did on the produce safety rule. Folks were concerned, well, I don't understand, how do these geographical limitations play in if somebody comes and buys my food at the produce auction? I don't know where they're taking it. I don't know where they live. For the consumer, the geographic restrictions don't matter. Those geographic restrictions only matter for the restaurant or retail food establishment. Okay, so if you are a qualified exempt, if you fit into that qualified exempt category of FSMA, and specifically the produce safety rule, it doesn't mean that the produce safety rule doesn't apply to you. It does apply to you. It just means that you're subject to the modified requirements of the produce safety rule. So all of these sections of the law here are still applicable to you. So you still have to keep records, and I'll go over here in a minute. You still have to worry about compliance and enforcement. You still have to, you still be subject to your qualified exemption being withdrawn. So important to note that it's not a get out of jail free card. It just means that a modified version of the law is applicable to you. So, okay, what does that mean? What do I have to do? One of the things you have to worry about is labeling. So there's some labeling requirements that are part of the qualified exemption. So if a food packaging label is required on the produce already, if it's something that has to be sold individually packaged and it's already legally required to be labeled, according to the modified requirements, you must include prominently and conspicuously on the label the name and the complete business address for where the produce was grown. So of the farm, has to have the street address, P.O. Box, city, state, and zip code. And the date for that by which that has to start is January 1st, 2020. For produce that does not otherwise require a food packaging label. So if it's something that's sold in an unpackaged form, the name and the complete business address of the farm that produced the food must appear on either the label on the produce container, such as the carton containing it, a sign or a placard at the point of purchase, or documents delivered with the produce, such as an invoice or a sales receipt. And again, the name and the complete business address of the farm where the produce was grown has to be displayed prominently and conspicuously. What exactly does prominently and conspicuously mean? I don't have a great answer for that. I think, FDA is still working through some of this. I would think, at this point, try to use your best reasonable judgment. I will be keeping an eye out for this because I know a lot of folks have questions on these specific labeling requirements. If I find some more information and as FDA starts to give us some more interpretive guidance on this, I'll be sure to add that information to the ALEI Food Safety webpage so you can keep an eye out for it there. I think somebody asked me a question. Let me see. What about the scenario about the grower selling to a local food co-op who in turn sells directly to the public or co-op members? If the grower is selling to a co-op and the co-op's then turning around and selling directly to the consumer, that would be a qualified end user. Okay, labeling compliant states. So we talked about if the food is already legally required to have a label, there's one date. If the food is not required to have a label, there's dates, and those dates are dependent on the size of your business. So for the produce safety rule, the compliance dates are broken down based on the size of the business. And the size of the business is like laid out here, more than $25,000 in the previous 3-year period of produce sales, but not more than $250,000. You have a little bit more time. You have until January 2020. And if you're a small business, you have until the end of this month. Those numbers are not adjusted for inflation. So that's important to note. The only numbers that are adjusted for inflation are the general cutoff number for the $25,000 for if the law is applicable to you, and then that $500,000 number to determine whether you're qualified exempt. Okay. Another important thing that folks who are qualified exempt need to keep in mind is the record keeping requirements to prove that you are in fact qualified exempt. So you need to keep records that show the farm's food sales for the previous 3-year period are below the sales threshold, so are below that $500,000 adjusted for inflation. And again, you can look at the FDA website for those inflation rates. That's where I find that information, and they keep it updated. And like we talked about, that you're selling more food to qualified end users than not. So that you're selling that 50.1% to qualified end users, and that the purchasers are in fact qualified end users. So you've got to keep those 3 basic categories of records. And this is definitely something that I would think that most folks probably weren't intentionally keeping these types of records before. So this is a new practice that people are going to have to adopt and get used to, and adopt some new practices in order to comply with the law. The University of Wisconsin Extension has created some useful tools to help growers calculate these different categories. So I've given you that link there. Not a specific endorsement of those tools. I think the explanations are helpful. Take a look at those, and if, hopefully maybe those will provide some guidance for you. You don't have to use those. They're not FDA approved or recommended, but I think they're helpful. These records, your sales records, which I know, farms are going to keep sales records anyway, but specifically for these purposes, these just need to be maintained internally on the farm. They don't need to be submitted to, in our situation, our Maryland Department of Agriculture or the FDA or any other states, the states that are doing the implementation. They just need to be maintained internally, so if there is an audit, or if your state Department of Ag, if that's who is enforcing FSMA in your state, or FDA, if they ever asked for them, you could produce them. You also need to keep, oh wait, I got a question here I will try to answer before I move on. Okay, so a grower selling at a farmer's market is going to need to keep records of the purchasers and that these purchasers are qualified end users. Yes is the answer to that question. You don't need to keep, super specific records in terms of, Bill Jones bought a carton of tomatoes kind of thing. However, I would keep records that you sold at farmers markets, that this was how much I sold at the X farmers market on X date. And selling directly to consumers at farmers markets is going to be understood that, that's a clear direct to consumer sale. And so as long as you have records proving that you sold a certain percentage at the farmer's market versus a certain percentage to a grocery store versus a certain percentage to a restaurant, that type of thing. If you have records that can help you delineate the type of buyers that you had, that would be helpful. And the same situation with the roadside stand. I mean, with records as specific as you can get, it's going to be beneficial to you, but I know in some situations it would be near to impossible to try to keep track of every sale you made at a busy farmer's market on a Saturday morning. So take a look at those Wisconsin tools, and I think that will give you some ideas for how you can keep track of that. They created an Excel sheet, which I think could easily be duplicated or used if you find it to be useful, and it's a good example of how you can do that. So you also need to keep a record reflecting that you've performed an annual review and verification of your farm's continued eligibility for the qualified exemption. So every year that you are subject to this law, you need to verify that you still are qualified exempt, because it's a rolling average. Because in order to be qualified exempt, you have to look at the previous 3-year period. So in order to be able to confidently say that, you have to stop, look at your books every year, and make sure that that's actually still a true statement. This record, one more question. Benjamin's asking me, aren't the sales records themselves sufficient documentation that the grower is doing an annual review? No, is the answer to that. You need to do you need to have proof that you've actually done that annual review. The sales records will be what will back up your annual verification, but you need to have one record, and I'll give you an example here in a second of a very simple way you can do this. That needs to be dated and signed by the supervisor or the responsible party to prove that you've done that annual review. It would seem in the produce growing context, this is something that you could put on your, winter to-do list, that you sit down every year, take an assessment of your sales records, and make sure that you still fit into the qualified exempt category. Okay, so here's an example. This is created by the Produce Safety Alliance, so I gave you the link to this record. There's a lot of, the Produce Safety Alliance has created quite a few template records. Just like the information I provided the link to from the University of Wisconsin, it's not that these have been approved by FDA, but they're an example. So it's just a real simple form. Name, address, farm, date, sales for the year, average total food sales, and then the number, this dollar amount of sales to qualified end users. So you can get that percentage to prove that you've sold 50.1 or more percent to qualified end users, and then an opportunity for the supervisor to sign and date at the bottom. So as long as you have something similar to this, doesn't have to be this, you can use this within your records, then you will be compliant. Okay, a couple of questions about record storage. Do you have to store your records on site? You don't. The law provides that off-site storage of records is permitted if the records can be retrieved and provided on-site within 24 hours of a request for an official review. Can you have this all electronically? Yes. Electronic records are considered acceptable and are considered to be on-site at your farm if they're accessible from an on-site location at your farm. How long do you have to keep all these records? The general rule is that you have to keep them 2 years past the date the record was created. However, we've been talking about these 3-year averages, so there is an exception to that general provision in the law that says records that a farmer is going to rely upon to prove an exemption have to be retained as long as necessary to support the farm's status during the applicable calendar year. Okay, so the qualified exemption, it seems like a pretty good deal. However, it can be withdrawn. A farm's qualified exemption can be withdrawn by the FDA if there's an active investigation of an outbreak of a foodborne illness that's directly linked to the farm, or if the FDA determines it's necessary to protect the public health or mitigate an outbreak based on things that are associated with the farm. So, if a qualified exemption was withdrawn, then the farm would be subject to the full requirements of the produce safety rule. And so the next question typically is, could I ever get it back? Could I ever be qualified exempt again if my farm was associated with some type of outbreak or the FDA thought that qualified exempt wasn't appropriate? It can be reinstated if the FDA determines the outbreak was not directly linked to your farm and or it determines that the problems associated with your farm have been adequately resolved and that the withdrawal of the exemption is no longer necessary to protect public health. So qualified exempt farms, they're not legally required to follow all of the produce safety rule provisions like we've talked about, which touch on a lot of different things, including but not limited to worker health and hygiene, sampling and testing of agricultural water, sanitation of equipment, a variety of different things that are really at this point the recommended best practices for produce growers. And so even if you're qualified exempt, I still think it's advisable for folks to the greatest extent possible, learn about the produce safety rule provisions and adopt them because they're the gold standard, because the farm will be in the best situation to prevent foodborne illness outbreaks, which no farmer wants to cause, and because the FDA can withdraw that exemption at any time. And if the FDA did withdraw your qualified exemption, then you'd be in the position of quickly having to come into compliance with a lot of different requirements that you may or may not already have in place on your farm. So a farmer is well served to do what he or she can do to prevent food safety risks. And so if they have not already, farmers should consider attending a produce safety rule grower training and scheduling an on-farm readiness review. So in Maryland, we have 2 produce safety rule grower trainings coming up in February. If anybody needs more information about that, they can find it on the MDA website or they can find it by contacting me. And we also are offering on-farm readiness reviews in Maryland, and I know a lot of other states are doing the same thing. So you can call the Maryland Department of Agriculture or your state Department of Agriculture if you're tuning in from out of state and ask if an on-farm readiness review is available to you. Folks from your Department of Ag will walk around your farm, talk about how your farm is or is not in compliance with the produce safety rule and give you some recommendations of things you can do so that you can be in better compliance. It's not a regulatory action. You won't be subject to, fines or anything like that. It's a voluntary thing where you can basically get an audit and get some help with compliance. So like I said, we have more FSMA resources on our website. We've also posted on our website the fairly recently released FDA Produce Safety Rule Compliance Guide, which I find to be helpful as well. So that's all on our website on the food safety page. So there is my information, my email, my phone number. If anyone has any questions or needs more information about anything I mentioned today, feel free to get in contact with me. And if anyone has anything else, they can type it in the chat box. Okay, I have another question. If I have a produce farm, grain farm, and cattle farm that are different companies, but I own them all, are these companies' sales individual, or do I need to combine them for calculating the QE status? I get this question a lot. I don't have a specific answer from FDA on it. At this point, I think you would be well served to, I'll start at the end, to comply as much as you possibly can with FSMA and with the produce safety rule. However, if they're individual entities, I can see where you would be able to calculate their food sales separately. So I think at this point that's all I can say, but Cal, why don't you email me that question with a bit more specifics, and I'll be happy to try to provide you a more official answer on that. Can I please, let's see, sorry. Can you please send out the resources in your presentation to the participants? I should have mentioned that. So this webinar is being recorded and will be posted on the ALEI and I believe the MDA websites following today's presentation. So give me until Monday, and then I will get this up on the ALEI food safety webpage to be able to download it. So is the expectation that growers just keep these sales records internally, not submitting them to FDA or their state departments of ag? Yes, so you need to keep these records for audit purposes. So the expectation is that you're going to keep these sales records internally and keep that annual verification unless your state's requiring something different. And if you're asked to submit that to someone, then you have all the records you need and you're going to be in compliance. Are wholesalers considered end users? No, wholesalers would not be considered qualified end users because they would then be selling the food to someone else. So wholesalers would not be considered qualified end users. To be a qualified end user, you either have to be a consumer, a restaurant, or a retail food establishment. Keep going down through these questions. I'm not seeing the dates of the upcoming FSMA trainings on the MDA website. Should I be looking somewhere else? I can tell you the dates of the upcoming grower trainings. They are in Leonardtown on February 11th, and Frederick, Leonardtown, Maryland, February 11th, and Frederick, Maryland on February 20th. And if you go through the events on the ALEI website, they will both be there, the upcoming events. Okay, next question. I assume sales ornamental nursery stock do not count towards the $500,000. Also seed sales, like vegetable seeds to regional seed companies. Ornamental nursery stock would not be food, so no, that would not qualify. Vegetable seeds, regional seeds companies, I do not think that that would qualify as food, but I would need to check the definition of food to verify that. So if you email me that question, Dawn, I will send you that direct definition of food so that you can have a correct answer for that. How long do states need to keep the QE records? States wouldn't. I'm not sure the answer to that. I'm not exactly sure what you mean by that question. States need to keep the QE records. Farmers need to keep the qualified exempt records for at least 3 years so that they can prove those 3-year averages. I'm not sure what you mean by states. Next question is, should we be posing these more difficult legal questions to FDA TAN? Sure, that's a great point. The FDA does have a technical assistant network, and yes, they are in the best position possible to answer these questions, and the Technical Assistance Network is where I got some of the information I provided you today on the auctions and the food hubs. So if anybody shoots me a question today that I am not qualified to answer, I will definitely submit it to the FDA TAN. If the wholesaler only sells to businesses within 275 or the same state, would that wholesaler food hub be a qualified end user? I do not think so, because they would not fit the definition of a restaurant or retail food establishment. Those definitions are found within the law, and I don't think a wholesaler would fit either of those definitions. It's specifically that it either has to be a consumer or a restaurant or a retail establishment. But Benjamin, if you email me that question, I will email you those specific definitions so we can be sure that we're on the same page about that. Okay. These are all great questions. I appreciate them. If anybody else has any other questions, feel free to email them to me. And I will try to collate all these answers from these individual questions and email them to the group, assuming everybody's interested. Thank you for tuning in today, and I look forward to communicating with you guys over email about all these questions. Thanks.